Broadcasting from the world headquarters of the National Floor Safety Institute is America's slip and fall guy, Russ Kenzie.
This is America's slip and fall guy, Russ Kenzie. Thanks for listening to my podcast. You know, oftentimes I'm asked by people who are not familiar with the legal system, how is it that a person who may have been injured go about filing a lawsuit, and whether or not there even is a lawsuit, because just because you're injured doesn't necessarily mean there's negligence. And so joining us today is Jason DeSouza with the DeSouza Law Firm in San Antonio, who works on personal injury cases of all different types, including slips, trips, and falls. So welcome to the program, Jason. Tell us a little bit about what is a personal injury attorney. What do you do?
Well, personal injury attorneys are guys who file suit against companies, individuals, insurance companies who cause some sort of injury to another person. So I do trucking cases, 18-wheeler cases, company vehicles, slip and falls, product liability. And people hire me because they were injured because of somebody else's negligence. And that negligence word is one of these, it's not a big word, but it's a word that holds a whole lot in it. And essentially what it means is somebody else was careless in some way, and my client was injured because of it. Now,
are personal injury attorneys the same as a trial attorney? We hear that phrase as well.
They can be. I consider myself to be a personal injury trial attorney, but there are a number of personal injury attorneys out there for whatever reason who are not comfortable going to trial. So guys like me are the ones who, if they're lowballed by the insurance companies, will take a case to trial and we'll have the jury decide what's fair.
Now, a slip and fall or a trip and fall case is commonly referred to as a tort. Is that correct?
That is correct, yeah.
What is a tort?
Well, a tort is a suit that's based on negligence as opposed to based in contract. So if there's a dispute between you and your landscaper, for example, and you have a deal to cut your grass for $50 every 2 weeks and they don't do it, well, that's going to be a contract-based suit. A tort-based suit is something where somebody is injured in some way or harmed in some way, and you hire an injury lawyer to bring a lawsuit on your behalf because of that injury, either to your property or to your body.
So let's take a closer dive into this. Just because somebody is hurt doesn't necessarily mean that the defendant was negligent. Just because somebody gets hurt on a premises doesn't mean there's negligence, meaning there may not be a lawsuit. So how do you kind of walk us through this? How do you handle cases that are presented to you? I mean, how do people find you, first of all?
Well, they can find me a number of ways. They could Google me. You can look up DeSouza Law. Our Facebook page is extremely active. We post every single day about trucking cases, slip and falls. We post articles about answering questions about, what is negligence? What are construction worker injuries? What is workers' compensation? So you can find me on Facebook. Word of mouth is a big way to find me. We advertise on television as well here in South Texas. I'm in San Antonio, so we advertise a lot on television. But the number one question that I will always ask somebody when they call me and they say they were injured is, can you point to what somebody did wrong? And if you can't point to what somebody did wrong, well, then I think you're going to have a little bit of difficulty with your case, because that's what you have to be able to tell the jury. Well, this oil company did something wrong. This grocery store did something wrong. This trucking company did something wrong. And sometimes people don't know. They know that a wrong was done to them, but they don't know who did it. And that's kind of what I'm trying to ferret out. But a lot of times people will call, and for whatever reason, there is what's called in the law, they call it contributory negligence. They contributed in some way to their own injury. And when there's cases like that where it looks like they contributed at least half, more than half to their own injury, for whatever reason, they're not for whatever reason, they're not going to have a case.
So what does the law require in a slip and fall or trip and fall case? I mean, what's referred to as the standard of care that's violated? What's the principles that the law requires in order to succeed in a personal injury case for a plaintiff?
Well, slip and falls are extremely challenging cases. Premises liability, they're called premises liability cases in the law. Slip and falls, trip and falls, oil field issues. And they're extremely challenging cases, and lawyers can be very, very selective in how they take them, because whenever a trial lawyer is always looking at a case from the end, and then they work backward. So they want to see at the very end what is going to be presented to the jury for when the jury makes their decision, because at the end of the day, every case for a trial lawyer could potentially go to trial. So they're looking at least four things, okay? They're looking at, number one, was there some sort of warning? Was there a warning, or was there not a warning? Number two, they're looking at, was this slip at the front of a grocery store? You walked into the grocery store, you slipped on water at the front. Was that considered an unreasonable risk of harm? Number three, you're looking at, should that grocery store knew or should have known of this unreasonable risk of harm? And finally, you're looking at how much of your own fault, Mr. Plaintiff, Miss Client, were you responsible for? Should you have been watching where you were going? Is this an area that's a high traffic area, and the cashiers should have been looking out for seeing if there's water? So there's four things we're looking at. Number one, and I'll just reiterate, a warning is an unreasonable risk of harm. Should the store knew or should have known of this unreasonable risk of harm? And how much did the person contribute to their own injury?
How do you actually build your case? Say you get a call from a client, you go through the screening process, you decide to take the case, and you got to build the case. Now, building the case can be very lengthy and very expensive over time. So walk the listeners through how you actually build your case from the beginning to the end, or as you said, from the end to the beginning.
Now, the main thing that I'm looking at, apart from what those four issues are that pop up, is the severity of the injury. And the reason why I'm looking at severity of the injury isn't because a person's injury doesn't matter. Every single injury to me is concerning. The problem, though, comes down to this. Plaintiff attorneys, whether they try cases or they don't try cases, have to put a lot of money into cases. We're spending anywhere from $50,000 to $150,000 of our own money that's going into these cases. We've got to hire experts. We've got to pay for filing fees. We've got to travel around the country taking depositions. We have to pay for the doctor's depositions. So what I'm looking at is, if we're satisfying those four prongs there, what I'm looking at then is the severity of a person's injury. If somebody's going to walk into a grocery store, and I'll give you an example. One of my former clients, very, very sweet lady. She walked into a grocery store. She walked in maybe 8 feet, and there was a huge puddle of water there. Slipped, fell. She must have gone up in the air before she landed on her right shoulder. So she went to the emergency room. She was seen over there. They did CAT scans on her. And I agreed to represent her. Number one, because when you walk into a grocery store, you got to think, hey, this place is safe, right? I'll encounter fallen grapes in the produce aisle. Maybe there might be spilled soda in the soda aisle. But when you walk into a grocery store, you don't expect to walk in, 6 to 8 feet and take a spill. So I agreed to accept her case. And she went into treatment. Her doctors ordered MRIs, and you could tell immediately that she had a torn rotator cuff. So she needed surgery. In cases like that, those are extremely valuable cases and she ended up having the surgery. And in cases like that, they're extremely valuable because I know that there will be a good settlement at the end of the day, or a jury will really understand and connect with the store's negligence and how dangerous of a condition that was at the front of the store. So it's a combination of all those things. I'm looking at those four factors: warning, unreasonable risk of harm, knew or should have known, and percentage of fault. I'm looking at where it happened in the store. Did it happen right where there was a whole bunch of cashiers, or did it happen in the kind of a quiet area where they keep the toilet paper? The other thing we're looking at then is then the severity, the extent of an injury. And we put all that together at the beginning. We got to make real quick decisions because it's also an extremely competitive business. Because if I don't pick up that case, there's 10 other lawyers who are looking at that case too that may want to pick it up.
Well, how does a person who is looking to hire the right attorney for their case go about doing that? I mean, if somebody in, say, Michigan is listening to this podcast and says, "Hey, I've got a slip and fall case, but I'm in Michigan. I can't call Jason because he's practicing in Texas." Just what are the guidelines that you'd recommend a person that's injured? How do they go about finding that right attorney? You mentioned there's a lot of attorneys out there. That's a fact, but you want the right attorney for the case. So walk us through how the injured party would select the appropriate or right attorney for their case.
The vast majority of people who hire me come from referrals. Despite us doing all the advertising and the blogging and the Facebook advertising, the main way that people hire me is based on referral. They'll ask a friend, "Do you know a good lawyer?" And I have what I believe are excellent client relationships, because clients to me are the most important people. I always tell clients when they hire me, I say, "Hey, I'm giving you my cell phone number, and only two types of people have my cell phone number: clients and defense lawyers. And defense lawyers only have my cell phone number to call me and pay my clients money. Otherwise, there's really very little to talk about because we can do that over email." So I give my cell phone number to clients, and that's what I would say is the number one thing. Ask a friend of yours, ask a family member, put it out on Facebook, and you'll get recommendations. And then from there, go and look at what their clients are actually saying about these people on Google. Look them up on Google. Just like the way you buy something off Amazon, you want to know, how many stars is this product? Well, how many good reviews does this lawyer have? What are they saying about this lawyer? If you go and look at me on Google, if you look up DeSouza Law, DeSouza Law, I mean, right now you're going to find 98 5-star reviews on me because clients and people in the community really, really like me, and I make a point to connect with them. And that's how I get a lot of my business.
Well, you and I have worked together on several cases in the past where I participated as an expert witness. You mentioned that earlier about the cost of a case and you have to hire experts. What kind of experts do you hire? How do you go about finding the right expert for your cases?
Well, again, we start at the end and we look at the jury charge. And I'll give you an example. Russ, you were one of the independent experts we hired. And before I answer this question for you, if you don't mind, I just want to make a distinction. When a lawyer hires experts, those experts are completely independent. I mean, their job is to be hired to assist the jury with understanding the issues. So the fact is that I've hired experts before who've said in depositions, "Well, I think the defendant's point, whatever defendant is trying to prove his point, is correct in what they're saying." Just because the fact that they're hired by one side doesn't mean that they're there to advocate for that side. They're there just to explain the issue for the jury. So going into the hiring of experts part, what we do is we look at what the jury charge looks like. So in a slip and fall case, the very first page of the jury charge that goes where the jury has to make a decision are those 4 factors. So in our most recent trial result, we were fortunate and we had a great client. I hired great experts. We had very good facts, and jury returned a $19.3 million verdict for us. Well, when I brought that case on, what had happened is my client had gotten his work boot stuck in a pallet below a box of watermelons. Now, most people would say, "Hey, man, watch where you're going." Well, nobody walks into anywhere with the intention of wanting to get injured. It just doesn't happen. You don't try to get hit by an 18-wheeler. You don't try to get hit. You try to slip and fall in a grocery store. You don't try to blow your arm off in the oil field. It just doesn't happen. So what I looked at was this an unreasonably dangerous condition, having pallets below a watermelon? Well, anybody who's done any form of warehouse work, my father, for example, he owns a machine shop in Toronto. He knows you got to get pallets can be extremely dangerous. You got to, as soon as they show up to your shop and you unload whatever you have on them, get rid of them, get them out of there. They're a tripping hazard. They're dangerous because nobody really cares about pallets. Nobody thinks about pallets. There's no quality control associated with pallets. So I said, "Hey, I think I'm going to hire Russ Kensor, to help me meet this element so he can explain to the jury whether this is an unreasonably dangerous condition. I hired another expert out of California to help me explain the new or should have known condition. That is, do grocery stores know that pallets can be dangerous? Now, the defendant in this case said, no, that doesn't make any sense. I've been in the grocery business for 40 years. Well, our expert from California showed up and said, well, I've been in the grocery business since I was 11 years old, and he's 75 now. And he said, I've known about pallets since the 1980s. And if you go to any form of convention or trade show, there's pallet guards, there's pallet skirts, there's ways to merchandise without pallets. There are plastic pallets. I mean, there are a number of ways and alternatives that are built to these pallets. So we said, hey, look, we need these two experts to help us meet the liability elements. And then we had additional experts that helped us meet the damage elements, the lost wages, the pain and suffering, the medical. My client had elbow surgery and a neck surgery. So we have different experts to help the jury explain different elements of the case.
Well, I know the call for experts is oftentimes diverse, and I get calls, as you do, every day. In my case, I get calls from attorneys regarding potential retention of my services in a case. And, I'll ask them what happened. How did it go? Give me your story. Kind of tell me the story. And if the story doesn't make sense, I'll tell you. And I may have said this to you, Jason. I can't help you. You just don't have a case that's going to go anywhere. So don't, drill a dry hole, because as you mentioned, it's expensive. Hiring experts, just the entire process is lengthy and very, very expensive. So if you kind of have a case that's not really going to go anywhere, or there's just no negligence, in my view, the defendant met the burden, then I can't help. And oftentimes I'll just, tell the attorney you don't have a case, and I wouldn't really pursue it. So that does happen. But you mentioned the whole process here. You're hiring experts. You're spending a lot of time. You're spending a lot of energy. Ultimately, the goal is to reach some form of a settlement. I guess most cases do settle. Most cases are handled through an insurance company, a claims process, which we'll talk about in a minute. But take a minute and explain how the process works if you don't settle. If you have to go to trial and you're dealing with a judge and a jury, how does that work, Jason? How does the selection of juries go? And what does that process look like?
So oftentimes in the state of Texas, every case is required to go to mediation. Now, mediation is just a process. It's not a binding process, not like arbitration. Arbitration is binding. Mediation is non-binding. You can show up and the insurance company will give you your best offer. And I tell my clients every day, I say, hey, whenever we go to mediation, I say, hey, look, nothing bad can happen at mediation because nothing will change if you don't accept their offer. And any day somebody is offering you money, that's a good day. Regardless of how much money they're offering you, it's still a good day. So if a case doesn't settle in mediation, what we'll do is we will take depositions. And in, let's say, a slip and fall, trip and fall type case, we will have already taken a number of depositions of the store staff, of the managers, of their corporate representative. We'll also start taking expert depositions. We'll take Russ Kenzor's deposition. We'll take Dr. Siddiqui's orthopedic surgeon deposition. We'll take a number of different depositions, and then we'll get all that ready for trial. We'll announce to the court, hey, look, we need about maybe 5 to 7 days to try this case. We show up to the courthouse, and we start day one by doing what's called pretrial motions. We'll say, hey, look, we need to exclude this evidence because there's no relevance to my guy getting busted for shoplifting 15 years ago. It has nothing to do with this case, him slipping and falling at this Walmart in 2017. Okay, they'll say they agree or disagree. We'll talk about different kinds of motions. Basically, what we're doing is we're setting the rules of the game. After that, we'll pick a jury. And generally speaking, that's going to be a pool. That's called jury selection. And that'll be a pool of about 60 people or so. And we'll ask them different questions. And we'll say, hey, what do you think about people filing lawsuits? What do you think about people who are injured at grocery stores? This case involves a person who was walking down an aisle and there was a large pink liquid that was sitting there and they slipped on it. What do you think of that? Do stores owe owe a duty of safety to everyone at all times. And, you get all kinds of different answers from people. And I always tell the jury members it's called the veneer panel. I'll always tell them in the veneer, look, whatever you say, there's no wrong answer to it. Whatever you think is what you think, and how you feel is what you feel. We just want to know what you think. Now, jury selection is actually a misnomer, because we're not actually picking a jury, we're deselecting a jury. So what that means is, out of those 60 people, I'm going to say, hey, look, we're going to go back to our room at the end of jury selection. And after I do my questions for about an hour of the panel, the defense lawyer does his. Then we kind of go back to our respective rooms, and I say, hey, look, we get 6 strikes. And we get 6 strikes for any reason whatsoever. So I'll say, hey, you know what? This guy, his wife works at Walmart, juror number 2, get rid of him. So we'll strike him out. Juror number 12, this guy said that he thinks that stores can do no wrong at any time. Let's get rid of number 12. They'll be in their room and they'll say, juror number 4 thinks that every time you walk into a grocery store, there's negligence everywhere. They'll get rid of that person. So we'll strike 6 people, they'll strike 6 people, and whoever is left over from the top down will take the first 12 people. So if juror number 1, juror number 7, juror number 9, 10, juror number 14, 15, 16, etc., the first 12 people who didn't get struck get on the jury. Once we get on the jury, we're going to do opening statements. That's where I tell the jury what I get into the case a little bit more. I tell them what I'm going to be presenting to them. I show them, this is the evidence that I'm going to show you. And at the end of the day, I will be asking you for a large verdict amount based on the negligence of this company. The defense lawyer will show up and he'll say, nope, we don't think there's anything there at all. This is just an accident. We think the plaintiff may have contributed in some way. And defense lawyers, they have a number of different strategies they go to for defending their cases. And then after opening, we'll get into the evidence. We'll start calling witnesses up. At the end of putting on the evidence of all the witnesses, we'll get into our closing arguments. And the closing arguments is where you just talk about everything you just heard. It's called summation. And we'll get into what this witness said and why it meets this element. Hey, Russ Kenzior said that this pallet is dangerous for this reason. This expert from California said that the store knew or should have known about this because he's known about it since the 1980s. They should have known about it. Obviously, there's no warning on a pallet, and they admitted there was no warning to getting your foot stuck in a pallet, and that's kind of what we do. And at the end of it, I will do my closing for about an hour. The defense lawyer will do their closing, and then I get the final word as the plaintiff's lawyer, do what's called a rebuttal close, and that's usually going to be about 5 or 10 minutes, and that's where I really drive it home and drive the case home for the jury.
Now, a lot of these cases obviously involve insurance companies, and I've learned through my experience, at least in the state of Texas, that during a trial, you cannot use the term insurance, right? Is that correct? You can't bring up insurance during a trial because that may skew the jury. And again, back to your deselection process, the goal is to just find if there's a particular juror that has a bias one way or the other, and that's the exclusion process. So you're not really, like you said, picking them, you're excluding them. But, during that process, the insurance companies oftentimes will have a representative present there, since they, most of the time, and maybe I'm wrong, Jason, but most of the time there's an insurance policy involved in this process. So the attorney that's representing the defendant is actually representing the insurance company. Is that a fair assessment?
No, you're absolutely right. That is absolutely right. The insurance company, the vast majority of the time, if you walk into your favorite grocery store and they're going to be insured with at least a $1 million policy. Now, we can't say the word insurance because technically the insurance company didn't commit the tort, the wrong, the negligence. It was Walmart or H-E-B or Kroger or Super S or whomever, who pick any grocery store. So we have to only say, grocery store did the following. The insurance company is just there because whatever damages are assessed by the jury, they're there to pay it. The only time that we can say insurance is where you're suing your own insurance company. For example, if you have a hail case or if you have an underinsured motorist case, or if you have a PIP case. If you're in Florida, PIP cases are huge. If you're in Michigan, first party cases are big, no fault cases. If you're in Texas, there's third party cases and there's first party cases. So the vast majority of the time, the cases are against a third party, which is going to be the other driver, the grocery store, the oil field company. But there is always an insurance company behind it. And it's always, generally speaking, the insurance company that is driving the lawsuit or the defense. It's going to be the insurance company that makes a decision on whether they pay or not. And the insured really has very little say. They can say, no, I'll give you consent to settle this case. I don't mind. But the insurance company, they say, no, we don't want to settle this case. Well, the insured has no choice but to sit there and have the finger pointed to them for all their negligence. And they can't say, well, it's the insurance company who's not making payment, because then that would result in mistrial, because you can't say insurance. Going back to that issue about the jury, the standard for a jury, Russ, you're absolutely right, is fair and impartial. So if a juror says, hey, look, I can't be fair and impartial in this case because I know John Smith, the plaintiff. I mean, I'm his friend. I've been his friend for 30 years now. I love the guy, and there's no way that I would ever find against him. And I've already decided this case in his favor. I cannot be fair and impartial. If they say they can't be fair and impartial, they're off. They're struck for cause.
No, on the insurance side again, it becomes complex because you have a defendant who's insured, but yet the negligence claim is against one party, the grocery store, but the cost, if anything, certainly the cost of the trial is being picked up by an insurance company. So there's kind of this rivalry, friendship, odd relationship oftentimes I've seen between the insurer and the policyholder. But let's say you either reach a settlement, you don't have to go to trial, or you go to trial and you're successful. The jury finds in favor of the plaintiff, and there's some cash disbursement. Oftentimes, if an injured party has surgery, and say they're elderly, so they didn't actually have to pick up the cost of their surgery, it was paid by Medicare. Whatever's recovered in either a settlement or in a jury verdict, all those costs come off the top. Explain to the listener, how does that work? How does that process work of paying your costs, paying your fees, any disbursements for medical costs, et cetera? Because a lot of people get really confused or misunderstand that process.
Right, and that's a great question, because a lot of times when I go back to signing clients, I'll sit down with them and I'll walk them through what my fee agreement is. And a lot of times if we get a settlement, let's use a round number, $100,000. And I'll say, Ms. Hernandez, we just got you a settlement we received an offer of $100,000 to settle your case. And she'll say, well, great. And I'll say, okay, well, this is what it means to you, because you're not going to receive $100,000. You got to pay the lawyers, you got to pay the case expenses, you got to pay the medical providers, and then there's a bottom line number that goes to the client. And that's what I always tell my clients. I say, hey, look, if you don't like that number, if you don't think that bottom line number that shakes out after paying the lawyers, the expenses, and the medical isn't fair to you, then you reject that number. I'm going to give you the up and down. I'm going to give you the good and bad, and that's my job, to explain to you what the risk is. But at the end of the day, I'm a trial lawyer, and my job is to go into trial and serve your interests. And if you don't like that number, then we're going to go in there and we're going to ask the jury for a larger number than that. Now, what I always make sure that my clients understand, I make sure I put it in writing, is these are the warts on your case. Okay, this is what's going on with your case. And the analogy I always use with clients too, and maybe some of my defense lawyer friends may not like this analogy too much, but people tend to really understand it. But I always tell clients, they have their case is like a beautiful white cake. Okay, a beautiful white cake. And the defense lawyers, when they show up with a bucket of cockroaches. Take that white cake, put it in a room, right? The defense lawyers show up with a bucket of cockroaches, and they pour cockroaches all over that beautiful white cake. And then they shut the door. Well, you go and open that door, you turn the lights on, and what happens? The cockroaches scatter. Now, are you going to want to eat that cake? It's still going to probably look about the same, but there's been cockroaches all over it. Well, that's kind of the thing that I explain to my clients. Hey, look, if we're going to go to trial, you got to understand that we're going to present that white cake, But that defense lawyer is going to pour cockroaches all over to the jury. So we got to be real careful. So, one of the things is that there are expenses that have to be paid, and trial lawyers cost money, and we don't get paid up front, and we don't get paid unless we recover money for you. But at the end of the day, what's happening is there's a lot of risk that lawyers like myself, lawyers that work for me, are putting into your case. And I don't pay any of the lawyers at my firm a salary. I refuse to hire any lawyer that wants a salary, and I'll tell you why. There is no reason that a lawyer should get paid a salary or get money when their clients are not getting any money. There's absolutely no reason in my mind for that. Now, I understand lawyers get paid a salary, and that's perfectly fine. I don't begrudge them. I just will not hire those lawyers at my firm, because what I want that lawyer to understand what it's like to sit in that client's shoes while they're out of a job, while their family is struggling, while they're injured. I want them to know that they need to maximize that recovery for the client. Now, having done that, when the settlement offer comes in, I also sit down with the client and I say, hey, look, there's some issues you got going on with your case, right? And that's going to be presented to a jury. And I think this offer is good, and I think it's good for the following reasons. And at that point, the attorneys have to be paid, the expenses have to be repaid, the medical, whether it's to Medicare, the health insurance company, or other providers, have to be repaid. And the bottom line number is what will go into the client's pocket.
Well, again, these are not easy cases to win. They can be very complex. They can take a very long time. Many plaintiffs occasionally just kind of give up. They get worn out. It's a battle. And the first tip I always give to people that have been injured is understanding that if you want to get into the fight, it is a fight. It's a long fight, and you got to have the right team, the right people helping you, assisting you. Because at the end of the day, there's a greater than 50% chance you're not going to prevail. And you've had cases, Jason, of successful outcomes and some that have not been all that successful. So what would be your last piece of advice to someone that's injured, contemplating whether or not to file a lawsuit, hire an attorney? What's your advice?
Well, so what the insurance company wants, they have a mantra. And that mantra is delay, deny, hope you die. So that's what you're up against. You're up against people who want to delay your case. They want to deny taking any responsibility. And as morbid as it sounds, they hope that you die, because if you die, your case dies with it. So the best piece of advice I have is be patient with your injury lawyer. Okay. I make a point at my firm to send out weekly updates for every case that we have. So the lawyers will make sure that they touch their cases once a week. The pre-litigation department will make sure that all the cases get touched once a week. And every Monday, one of my staff members will send out emails to your phone. So like it's an email to your text message. It'll be like, whatever your cell phone number is at verizon.net. And that'll give you an update of what's happened in the past week in your case. But you got to understand, a lot of people have to understand that this is a fight. When you hire me, for example, you're hiring somebody with a lot of fight. But the fact is that things just move slowly in the judicial process. I am one that has a lot of impatience. I am not a patient person. I want things to move quickly. I want them to happen now. I want them to happen yesterday. Okay. But the fact is that courts move slowly because they have to serve everybody. Insurance companies move slowly because for them, they have something called reserves. And in these reserves, they have to make sure there's enough money in there. There's scheduling issues. There's a lot of things that are going on. So just be patient with your injury lawyer, but at the same time, get updates from them. Understand that you are their customer and they owe you updates and they owe you a responsibility for what's happening. When they're as eager to sign you up, they have to stay as eager on your case throughout as long as it takes. If it takes a year, 2 years, 3 years, 4 years, 5 years sometimes, stay on them and just do what the doctor asks you to do. If your doctor's telling you get MRIs, get MRIs. If your doctor's asking you to get epidural steroid injections, do that. If you're a candidate for surgery and the support is there for it, go ahead and get that surgery and get yourself better, because you're only getting older and you're not getting younger and your body's getting older, and you got to hold these people responsible. So that's my last piece of advice, Russ. I know it's long, but I just want to encourage people to steel in the fight, to keep your boots planted and fight these insurance companies as hard as they're fighting you.
Well, we've been speaking with attorney Jason DeSouza from the DeSouza Law Firm in San Antonio. How can folks here in Texas get a hold of you, Jason, if they have a question or want to talk to you?
Well, Russ, I have 2 advertising numbers, and both of those advertising numbers, they come directly to my cell phone because I want to talk to people myself when they call. I'm very selective about the cases that come to me, but I still want to talk to people. I make a point to connect with them. So you can either call me at 210-910-HURT, or you can call my other number, which is 361-799-2222.
Wonderful. Well, thank you so much for spending the time going through the process of filing a personal injury lawsuit for a slip and fall, or really any type of personal injury. And we may call you back. I would
love to be back, Russ. I'd love to be back. Thank you very much for having me.
This has been America's Slip and Fall Guy, Russ Kenzior, reminding you to don't let your next step be your last step.